Hi, this is Bert Briones with Red Hill Law Group. Another question I get a lot of, and one that some people fear, is whether your spouse will be affected if you file for individual bankruptcy protection. So let's dive in. How will your spouse be affected? Because a bankruptcy can be filed by one spouse without the other, this is one of the most common bankruptcy questions, and there are many aspects to the answer. A bankruptcy filed by one spouse does not bring the other spouse into bankruptcy. Neither does the bankruptcy of a spouse give the non-filing spouse the full protection of the automatic stay or the bankruptcy discharge. Let's talk about joint debts. If you and your spouse are jointly liable to a creditor, the bankruptcy of one spouse does not relieve the other of paying the debt. Upon a bankruptcy, the creditor may look to the other spouse for payment, unless the bankruptcy case is under Chapter 13. What happens there is if a debt is a consumer debt and to be paid 100% through the Chapter 13 plan, the co-debtor is protected by what's called a co-debtor stay under Section 1301 of the Bankruptcy Code. Generally, marriage alone doesn't make both spouses personally liable for a debt. However, in California, most debts incurred during the marriage are considered community property debts. Therefore, both spouses would be liable for the debt, not just the person who signed the loan or credit application. Also, a joint tax return will make both spouses liable for the total of the tax due. Let's talk about joint property. If you and your spouse own property together, that property may be included in the bankruptcy estate and be potentially available to pay creditors. In community property states such as California, both halves of the community property come into the estate. All of the community property is available to pay creditors of the spouse who has filed. What is meant by a community property discharge? When one spouse files bankruptcy in a community property state, both spouses enjoy the protection of the filing spouse's bankruptcy discharge. Section 524 of the Bankruptcy Code provides that any community property that the filing spouse and the non-filer acquire after the bankruptcy is protected from creditors of the non-filer, even if this creditor held a claim against the non-filing spouse as of the date of the filing. A creditor with a claim against a non-filing spouse can only collect its debt from the separate property of the non-filing spouse. In California, that separate property is comprised of assets acquired before the marriage, assets acquired by gift during the marriage, or assets acquired by inheritance. Some people have a hard time believing that someone in a community property state gets the benefit of their spouse's bankruptcy discharge, but that's the law, and it has been since 1978.